Good afternoon, everybody. Welcome to CUHK Law. Welcome to today's Greater China Legal History Seminar. Thank you all for joining. My name is Lutz Christian Wolf. I'm one of the co-organizers of the Greater China Legal History Seminar series, together with my friend and colleague, Professor Steve Gallagher. We are very happy to have all of you with us today, and we are even happier to have a very distinguished speaker with us, Dr. Ka-Chai Tam, who is one of the few real experts on Ming Dynasty law. Dr. Ka-Chai Tam received his BA in history, first class honors, and his MPhil from CUHK. He then did his DPhil in Oriental Studies at the University of Oxford. After teaching and researching in the Hong Kong Polytechnic University and at CUHK, he has been serving in the Department of History of the Hong Kong Baptist University, where he's now an associate professor. Alongside legal history, his areas of interest include maritime and transportation history of East Asia from the 14th to the 21st centuries, and the development of historical geographical information systems. Dr. Tam has just recently published 3 books on Chinese legal history. The first one was Justice in Print, Discovering Prefectural Judges and Their Judicial Consistency in Late Ming, Casebooks, published by Brill in 2020. Then he has Ming Zhongwanji de Falu Shiliu Yu Shehui Wenti, published in Chinese in 2020, and The Spread and Restriction of Catholicism under the Judicial Perspective in Ming and Qing Dynasty, which he has co-authored. It was published in Chinese by by the City University Press this year, actually. Today's topic is controversies regarding the morality and effectiveness of judicial torture in late Ming China. But before I pass the floor to Dr. Tam, I'd like to make one housekeeping announcement. Dr. Tam has kindly agreed to take questions from the floor at the end of the seminar during the Q&A sessions. We have about 10, hopefully 15 minutes. Please use the chat function to send in your questions, and I will then read them out to you, and we will hopefully get a very good discussion going. Many thanks again to everybody for joining today. Special thanks to our speaker. And with this, over to you, Casey.
Thank you very much, Luz, for the very kind introduction. Can you hear me clearly? Perfect. So, yeah, perfect. Well, it is really my honor to be invited to give a talk here in a very prestigious institution of law in Hong Kong, and I am honored to be in the same array of the scholars presented before me. So it's a little bit, overexcited for me to have this very rare opportunity to share my findings and also my experience in doing research of the Ming Dynasty, especially in the legal field with you. So my honor. And let me first share the PowerPoint with you. So here you go. So the purpose of this seminar is to introduce you the court practice of late Imperial China, and I shall focus on the Ming period, which is the exact day of Ming period is 1368 to 1644, which is the only indigenous Chinese dynasty ruled the whole of China proper during the millennium before the 20th century. We shall explore the contradictory views of the late Ming period to the judicial torture from 2 opposite but interactive directions. The first perspective is the casebooks by the local judges, who usually campaigned against problems of tortures by unauthorized subordinates. And second, the contemporaneous popular novels in whose stories the judicial torture is lavishly employed by good officials who discover hidden details of the crimes and therefore effectively eliminate the evil. So one of the main sources of my study is the Casebook, 蒙水斋传读. The English translation of the title is Official Documents Preserved in the Mongshui Studio by the professional judge of Canton, Yan Junyan, whose office is from 1628 to 1633. This work comprises 1,316 case reports and also over 100 other official documents concerning the late Ming Guangdong province, among which 46 articles mention the application of judicial torture at court. So my principal question today is that how the late Ming people of different strata of the society, as represented by our sources, found the principles to manage such violent legal measures in the judiciary. So through looking closely at their struggles about fact-finding and legal reasonings at the Ming court, we could appreciate the experience of the legal tradition of China before the introduction of forensic science in the modern era, and have a glance to the possible emergency of legal professionalism in the 17th century China. So what is late Ming? I think the Ming Dynasty is very, many of you should be very familiar with, because it's a period of higher art of China. So indeed, the Ming Dynasty is famous for its art taste. The Ming style painting, furniture, and porcelain are recognized as the greatest art form of China internationally. They are products from a society, indeed, of affluence. Well, actually, in the later half of the Ming period, since 1550, the interregional economy had developed rapidly. This has shaken the foundation of the stable agrarian society decided by the Ming founding emperor, Zhu Yanzhang. This emperor is infamous for employing brutal punishment to suppress his rebellious subjects. At the same time, so it is a basic impression, many people to the legal history of the Ming Dynasty, because the founding empire is a very cruel guy who killed, who murdered thousands of people in the name of the law. Anyway, at the same time, in the late Ming period, European traders arrived to Chinese coast at ports like Macau. They exported Chinese goods globally by payment of Japanese and American silver, which further fueled the engine of Chinese economy by providing a convenient means of exchange for inter-regional trade inside China. New towns emerged throughout the Ming regime with a growing number of professional and literary handicraft workers residing in both the expanding urban centers and villages nearby. As an important element in the growth of the handicraft industries, private and commercial woodblock publishing flourished in the late Ming. Publishers produced hundreds of thousands of books of unprecedented varieties, including all kinds of novels and different types of judicial works. For the enormous reading public, some well-received works could sell thousands, tens of thousands of copies and give them over a good fortune. So they have the good intention to publish their works for the popular market. The influx of low-price books foster an urban population with wide reading tastes, which in turn constitute a strong market for different genres of literature. To manage these rapid changes, the original design of the Ming society is rather stable. The literate public and imperial court now demanded good governance by able officials with solid credentials. Against this social and intellectual background, some officials seized the opportunity to turn a profit by publishing their official documents in a popular form. That's why the 蒙水斋传读 by the local judge would be published. While for some others, their motivation in publishing accounts of their judicial achievements was to spread their good names so as to enhance their chance for promotion. it's not unlike the academics. They need to publish their good works in order to secure their tenure and promotion. So it is almost the same case in the naming of the officials, including the judges. These new publications, notably the casebooks, provide a foundation of research materials for inquiries into the solutions, because they need to publish real cases. They need to publish maybe solid evidence of their achievements. So the cases in our casebooks could be seen as authentic and maybe some sort of accurate reflection of the situation of the layman and also the legal procedures in the courtroom. They also include some frustrations of the layman judges in the courtroom during this turbulent era of social changes. Because what the rapid economic growth of the time makes people nervous, including the judges. They need to find the methods to manage the measures inside the courtroom. So now let me briefly introduce maybe something about the legal development of the Ming Dynasty. In his preface to Yan Zhunyan's casebook, Chen Zizhang, a famous and leading Cantonese minister of the central government, who is the minister of rituals. He's quite related to Matthew Ritchie in some sort of debates and also some controversial matters about the spread of Catholicism in China. But anyway, it's not his story today. But I just mentioned his viewpoints on the legal development of China. So he gives his authoritative analysis to the legislative history of his dynasty from the viewpoint of the last ring of the Ming. But well, mind you, at the time of his writing, he didn't realize that his dynasty is dying. Okay, so he's not concluding the legal development of the period, but just mentioning some of his impression to the earlier periods. So it is the code. At the very beginning of our dynasty, judicial sentences were governed by the Great Ming Commandment, Da Ming Ning. It was then revised and enlarged to form the Great Ming Code, Dai Ming Lu, and the Grand Pronouncements, Da Gao. The English translation of the commandments is found in the appendix of Edward Farmer's Zhu Yanjiang and early Ming legislation, the reordering of Chinese society following the era of Mongol rule. So it's quite a professional book, and translation is rather technical. But if you want to have maybe an impression on those commandments, which is published, promulgated at the very, very beginning of the Ming Dynasty, his translation, Farmer's translation, is maybe the only thing we have at the time being, in the time being. And Farmer's student, Zhang Yonglian, has continued the legacy and also the enterprise of translation of the Ming laws by publishing his own translation of the Great Ming Code. I think it's quite, in the field of Chinese legal history, it's quite a standard tool for the students and also the scholars studying the Ming law. And this one, I think, is rather recommendable for some sort of general reading. Although I myself find it a little bit too technical, and some Western terms of the Western legal terms should not be directly applied to the Chinese terms, because they are quite different in context. Anyway, this is the only thing we have nowadays in the time being. And he also published a companion study on the philosophical aspects of the statutes, the Mandate of Heaven and the Great Ming Code. And the above mentioned two works published by Zhang Yonglian by the University of Washington Press. So if you're interested in the history of Ming Dynasty, particularly in the legal field, they are important works to be consulted. Something else is quite quite interesting for the general public is the grand pronouncement. You know, the grand pronouncement is famous for, or infamous for its bloody nature, because many of the gruesome killings are reported by the Ming Founding Empire himself in this work, because it is intended to be, you know, a exemplary case book for the judge of the early Ming to consult, to borrow the experience of Zhu Yanzhang, the Ming Founding Empire, to deal with bad guys, the bad officials, etc. But unfortunately, this rather interesting word, we have no English translation till now. So maybe in the future people could work on it. But the grand pronouncement, you know, this very powerful law in the early Ming, its influence at court, however, had diminished greatly after the 15th century. The most influential study to this law is still the PhD dissertation, Zhu Yanzhang and the Great Ming, the Great Warning, autocracy and rural reform in the early Ming. It is a dissertation by Anita Andrew, and Anita's supervisor is Everett Farmer. So it's still from the Everett Farmer family of legal publication on the early Ming. So if you are really interested in those matters in the earlier period of the Ming Dynasty, this words in English could be wonderful sources for your inquiry. I myself published quite a little bit, maybe several articles on the early Ming development, but unfortunately they are all in Chinese. So maybe wait for me in the future. I may maybe write up maybe a legislative history of early Ming for your consultation, but it's not for now. Okay, let me continue Chen Zizhang's description and analysis of the Ming development. So he continued like that. Since then, these codes have supplemented by the regulation technique, the means by which the dynasty and ancestors unify all under heaven were extremely detailed. And within the law, there was nothing that was not completely perfect. Later generations have nonetheless gradually transgressed and forgotten most of them. So, you know, perhaps this is an accurate description of the order of the emergency of the formal codes of the Ming, and the combination of the first commandment, the code, the grand pronouncement, and the regulations form the backbone of the statutory law of the late Ming society. So unlike the early Ming legislations, the later laws are yet to be translated into European languages. So particularly the regulations, they are very important sources for the judges in the late Ming to decide cases. But you know, one of the major fallacies of scholars of Chinese legal history, when they deal with the late Ming legal problems, they seldom consult those regulations, and they see the law and also see the court practices simply, or many of them simply looking at the Great Ming Code. But the Great Ming Code, you know, at that time, especially after the 15th century, is almost outdated. Most of the judges decide cases depending mostly on the regulations. So the regulations should be the things that we need to remember, and also, if possible, to put an eye on that. So unlike the early Ming legislations that, you know, I just mentioned, the later laws are not translated into European languages, but still some people are working hard on that. A group of international experts on late Imperial Chinese law under the project Legalizing Space in China, funded by the French government, So the website is okay. I listed here. You may consult it, but you know, this project has already closed because lack of fundings. In the future, I hope that maybe I myself and also my colleagues could continue the wonderful work. But as scholars, this group of you know, of legal historians is still now working on the French and English translations of the regulations from the Ming and Qing periods. So we are still working on it, but you know, it cannot be delivered to the public very soon, maybe after some decades, hopefully. So as confessed by our project leader, Jerome Bourgon, who's the guy I saw in the PowerPoint, to one of his fellow team member, that is me, he said, this enterprise is going to be an everlasting one. Okay, if you try to translate the text, you know the difficulties of these things. You know, our group had discussed each word for days, so it would not be very practical to claim that it would be finished soon. But this sort of translation make us realize that our understandings to the naming legislation is still quite limited. Many rooms of possible development and also possible extension of understanding is possible. So if you are interested in Chinese legal history, maybe it's a nice direction for your pursuit. So it is important to point out that the Ming founding empire had prohibited the revision of the code promulgated by himself, so that legal officials of later times could only improve the legal system by supplementing the statutes with regulations that were very similar to the statutes but could be revised regularly. That's why it's quite complicated, because they are not stable. They could be revised for different purposes, or maybe for the different demands of the times. But new legislations alone were not enough to enhance judicial performance in an era of unexpected economic development after the mid-16th century. As parallel laws among codes and regulations, as I just mentioned, the judges not consulting the code alone, they need to consult the regulations as well. They may have created an even more confusions rather than solutions to disputes, because the judges and also maybe the different parties in the legislations could choose the favorable law among the code and the regulations to deal with their own situation. So there are many new confusions, and also this was created because of the introduction of the concept or maybe the method of regulations. But it is necessary because the society was ever changing in the late Ming, just like nowadays. Anyway, so by the beginning of the 17th century, many senior officials, experienced judges, and even commercial publishers, okay, how could they deal with the problem of the date? They had composed and published commentaries on the Great Ming Code and also handbooks on jurisprudence, and most importantly, collections of court cases. They all aim to enhance the good judgments of frontline judges that should be consistent and thus predictable. So it's some sort of legal professionalism development in the late Ming period by the evidence of such publications. And also, before going on, let me just add one point here. For the novels, why you know, in the late Ming period, many novelists, they try to include some sort of information about the courtroom. They like to write about you know, the judges, and also the crime fictions, including the judicial process, because this sort of you know, of popular introduction could really help the common people to know about to know more about the legal procedures, and also particularly on how could they write their complaint to be submitted to the court. So this sort of novels could be helpful to the general public on the introduction of legal practices, and also to give them some glance on the legal experience of the judges, so that they can understand their opponents, and also the judges more before going to the court. So why? The question today is the main theme of today. Okay, why judicial torture was considered necessary in the traditional Chinese legal system. So after introducing you all the materials, and also those struggles of the naming legal officials, judicial torture nowadays, all of us know that they are bad things. They should be abolished at all costs because they're useless. But during the Ming period, the people having the same conception to judicial torture, do they really don't know the shortcomings of them? Okay, I'm going to tell you that this is not the case. They realize everything, but they have the necessity to do it. The Chinese legal system in the late imperial period had established, however, a very strict rule that the judge convict the culprit guilty only after the latter had disclosed in his own mouth the truth of his crime and had signed by his own hands on the statement. So he confessed, he gave the written confession of everything. But this might have been all the same in earlier periods of the Chinese history, but we have no surviving code before the Tang Dynasty. It is about maybe 800 years before the Ming Dynasty. So it is hard to make the same claim. We have no evidence of the earlier periods, but at least during the Ming, the court, the judge need to produce the statement of the criminal so as to close the case. Anyway, it is indeed human nature to deny one's own crimes to avoid punishment. We all know that. In the Chinese court culture, it was widely believed that people must be forced to give the truth, because naturally the judges don't disbelieve that the criminals before them would produce the truth. Therefore, the traditional Chinese judges considered the judicial torture as an effective method to obtain the confession of the culprits. The Chinese legislators, such as the Ming Finding Emperor, however, realized that the pain of torture imposed to the accused is a double-edged sword that could also create injustice. To keep judicial torture under control, the Great Ming Code controlled the interrogation instruments, the prohibited targets of tortures, the criminal liability to unlawful tortures, and also the responsibility of the police officers in arrestments. And last but not least, other minor rules concerning false confession in different statutes and related regulations. So there are a set of regulations and instructions to those users of the torture. In short, only when all other instructions reveal us that only when all other circumstantial evidences and witness reports are all clear out, but the accused still refuse to give self-confession, judicial tortures according to the laws which may help closing the case are allowed. So it is conditional and very strict rules governing the usage of the torture on paper. Now, let me go further to see some real cases and the real struggles of our judges in the case books. The torture in Yan Zhunyan's case book, 蒙水毡传读, is revealing like the following. So let's go back to our inquiry on the layman people's attitude towards torture. The first source of our talk today for in-depth discussion is the casebook 猛水斋传读, it is by Yan Zhenyan, the prefectural judge of Canton. The Canton prefecture in the late Ming is roughly the area of the same Pearl River Delta, including Hong Kong and Macau. So it's interesting for people from Hong Kong like me to see those cases. It's like my own history. Anyway, the main duty of the prefectural judge is to review the case heard by the magistrates of the counties inside his jurisdiction. This post was unfortunately abolished in the early chain to save administrative costs of the local government. So it's another story. We may talk about the legal changes later. My book, Justice in Pain, Discovering Prefectural Judges and Their Judicial Consistency in Naming Casebooks, already gives full exploration to the duties and struggles of this important post in the provincial judiciary of the late Imperial China. So, I don't repeat on no expansion of the discussion of the duties of the prefectural judge here. So let's talk about the torture first. So, but before that, let me just introduce you very briefly about what is the casebooks from late Imperial China. The legal historians of China translate the Chinese term pandu into the English word casebook. You know, the original meaning of this American educational terminology in legal studies, which reads a book containing records of legal cases used to teach law by the induction of principles from cases. It is basically agrees with the general meanings of pandu of Chinese. So it is the collection, the pandu is the collection of exemplary judicial cases good for the understanding of the law and the reference of further future judgments. A prominent historian of Chinese law, Byron McKnight, he describes the characteristics of the Ming casebooks as following. The majority, compiled by lower-level officials, narrate the facts of cases, often in great details. They contain the written decisions all judges were expected to write when summarizing cases. So from those cases, we can really see the practice, the authentic practice of the courtroom in the late Ming. For basic information about Ming casebooks, you may see the scholars I mentioned before who translated the Great Ming Code is Zhang Yongnian, and also his co-author Wu Yanhong, she is an important legal historian working in mainland China, in somewhere in Shanghai. So they published the work satisfying both sentiment and law. Fairness center judicial reasoning as seen in layman casebooks. So this short article may be useful for you to have some sort of basic impression about the Chinese casebooks. But the authoritative introduction to this kind of legal works is the handbooks and anthologies for officials in Imperial China, a descriptive and critical bibliography, so which is edited by Pierre Itinéraire from the College of France. So who is also a mentor of myself, and his work is recently published, and it is very useful for researcher, because in the bibliography, Pierre Itinéraire and his team listed all the versions and also the available scholarship on different casebooks and also different official handbooks. So if you are new to these fields and new to these words, it would be a good introduction for you to know where to find those editions and where to locate available scholarship to this sort of interesting materials. I have talked too much about the sources, so let's go back to our Judge Yan Zhunyan. So for Judge Yan Zhunyan, his most frequent complaint towards judicial torture is about the unauthorized torture administered by the acting magistrate. So the acting magistrate, they were not the white person or the rightful official handling the court, but because maybe the absence of the formal magistrate, those acting ones would work maybe for a while, for a few months, to wait for the arrival of the new magistrate. So those acting magistrates who were merely unranked associate officials, in the Chinese term they are called 做二官, they are just assistants to the officials. But sometimes, because the absence of the magistrate, they acted like the judge in the county courtroom. So Yan's campaigns, however, are not about the judicial torture itself, but about its misusage by inexperienced and unauthorized personnel who were not fully informed the procedures, techniques, and possible liabilities of torturing people at court. So the magistrate, they were supposed to be well trained in doing this legal acts, but those associate officials, they were not. That's the origin or the roots of the complaint. The unauthorized torture administered by associate officials is by no means the worst problem, however, when comparing to the underlings, unlawful tortures practiced outside the court. So there are two levels of problems. The first level is the unauthorized officials. They are acting on the behalf of the magistrate inside the courtroom. But the worst problem is outside the courtroom, the illegal tortures done by the police constables. So in Liming Guangdong province, the police constables assigned to arrest the criminals were under great pressure to accomplish their duties. On one hand, they had strict time limits and other institutional restrictions hindered their choice of strategies because, well, they need to follow procedures. They need to, comply to rules. On the other hand, the bandits were ready to resist them with weapons, and even worse, they are hard to find. They cannot find the criminals easily because, well, I can tell you that maybe for the whole area of Hong Kong, for example, is half the size of a normal county in the Ming and Qing dynasties. So only maybe less than 50 constables were assigned to the region. So how can the 50 police officers could handle or could search all the criminals hidden inside this big area? So it's the problem of their duties. To tackle these difficulties, the constables usually employ contingent methods, including torturing suspects in their own houses. I mean the houses of the constables by extra legal equipment. Their major concern is not on arresting the real criminal as the judicial system required, but to make sure that the arrested people would admit the accused crime so as to close the case. So it's a very convenient way, convenient strategy for them to deal with the problem. So the time of in the late Ming, those constables, because of the punishment of the time limit, if they could not arrest the criminal within the time limits, late 10 days or 15 days, depends on the severity of the crime. They need to be punished very harshly by the officials. So they need to deal with the problem. They solve the problem by arresting perhaps innocent people who knows whether or not those persons are innocent. So they just arrest them and make sure them they confess. Okay, so this is the root of the problem of those illegal tortures outside the courtroom. The officials and the judges like Yan Junyan, they were not stupid. They were not uninformed about the situation. They fully recognized this police problem. So no later than in the early Chongjing era, this is the last reign of the Ming Dynasty, the senior officials of Guangdong promulgated some prohibition to the private usage of torture by all unranked officials and police constables. I mind you here, they repeatedly announcing such restrictions. That means they're useless. Yeah, because they need to repeat it from time to time, or maybe in each 2 years, like that. So it must be a widespread problem in the late Ming that made similar prohibitions had pronounced so repeatedly. And as we can find in our source Ming China, the casebook, no less than 3 different officials during the 6 years of Yan Junyan's service in Canton had announced such restrictions. The Ming China and other naming casebooks, however, give few hints to the reasons that the police constables favor the means of unauthorized tortures and detainments in their daily operations. So why they were so cunning, so lazy, so unlawful? The casebooks didn't give us the details. They were simply coldly criticized as cunning or corrupt by the judges. So they were scolded, but the reasons of their actions were not given by the judges. So supplemented by the details of the popular novel stories to caution the world. Okay, now let me introduce you the second important source of today is the novels. So the stories to caution the world, we call it 警示通言 in Chinese, is combined by the celebrated layman novelist Feng Monglong. In the later part of his life, he became a magistrate of a county in the Jiangnan area, in the Yangtze Delta area. But before that, he's a layman. He just wrote those novels at the capacity of an intellectual who want to earn a profit, make something appealing to the general public. Anyway, in his popular novel, the details and calculations of the application of unlawful torture by the police are well explained. So let's see what Feng Monglong told us. Okay, there are some more complicated institutional constraints, indeed, that push the constables to take the weights of those unlawful routes. In the story, Kak Jin rewards Si Tong with a pretty male servant. So the details of those parts, I'm not going to give you. It would be a very, very long story. Anyway, we are informed that the police constables may arrest suspects and integrate them with unauthorized torture so that they may find the suspect, and fulfill their duties by the strict time limit. So they need to find someone as the victim of the crime. If the integration led to the arrest of the real criminal, so from time to time, by chance, they may arrest the real criminal, the integrators, the police, could claim credit. But if the suspect refused to confess and had to be released, the suspect could then sue the integrators and charge them with framing an innocent person. So the problem is that once the so-called criminal or the suspect is arrested, if they were not found to be the real criminal, the problem will be in the constable's side. So the police constables will have trouble. The punishment for this crime for the police officers for false arrest is equal to the punishment for whatever crime the suspect had been accused of. So it is serious. if they arrest in the crime of like murder, the police constables, if they make the false accusation and false arrest, they will be punished according to the code of murder. So it is serious. So therefore, once privately tortured a person, the constables must then insist till the end that the arrested person is guilty and force him to confess by all means. That's the maybe the root of the injustice. We realize that the coast protection of common people from unlawful torture of police constables, nevertheless, may indeed increase the possible pain suffered by the innocent and create cases of injustice. So that's what the novel told us about the situation, or maybe the corruption of the cops, because these regulations on unlawful judicial torture, unlawful torture, they're not judicial. Okay, it's oxymoron. There's no, I think no unlawful judicial torture. They are not judicial anyway. So alongside unlawful tortures, as a repeated theme in his cases, Yan Junyan believed that it is unwise to decide a case solely on the ground of unreliable evidences generated by judicial tortures. So he know that the pain would not necessarily give the truth. Judge Yan also pointed out that the tortured persons just confessed under the pain in the magistrate's room, but retracted their testimonies once they were brought to the higher officials. So they can always refuse or maybe deny their confessions. So therefore, without good evidence or other good means to prove the culprit's crime, his confession obtained by judicial tortures was by no means enough to close the case. It is what Yan Junyan emphasized. So after this very brief introduction on the, on our study of the sources of the casebook, so let's turn our eye to the other source, the torture in the Laming novels. So Judge Yan Junyan's authentic experiences can be compared and supported side by side, as I just demonstrated, by relevant parts of judicial torture narrated in the Volga novel, Celebrated Cases of Judge Bao. So it's another word, another novel I'm quoting here, I'm consulting for the study. So this word, the Celebrated Cases of Judge Bao, was published in the late 16th century, and 54 out of its 100 stories contain plots of torture. So torture is widely applied in the cases of Judge Bao in the novel. And the more learned story, the other novel that I'm going to discuss is the story to caution the world that I just mentioned above. So among the latest 40 stories, only 9 contained plots of torture. So it seems it's relatively lenient, but it's not the case, because this lower proportion is the result that no more than a half of its stories involve the plot. So the stories caution the world may be about love stories, maybe about ghosts, or maybe about some filial piety practices. So it's about all things, but the proportion, or maybe the stories involving the plot, is just half the size of the total stories. So the proportion that in the courtroom torture is mentioned in both cases are, as a result, 50% about it's maybe the common factor that I discover in these two words. So the main justification of quoting these fictions to inquire the application of torture. We know that, we all know that they are fictions, they are imaginative words, but why they are still consulted to be our source of the legal history. It is because that they usually include information of interrogations not suitable to be recorded in the official documents. And also some small details so accustomed to the officials, they would not report them or mention them in the case reports because those are routine words. But these details are given by the storytellers to unfold his stories. So we know some details of the courtroom or maybe of the legal procedure because of the nature of the novel. They need to continue or maybe to make the narrative possible by giving us those procedures. So moreover, there's no record of the illiterate executors and police constables, unlike Germany and also France. In those countries, we have some testimony or maybe diaries of those executors. But in China, most of this type of profession are illiterate, so they cannot leave their records. And also the police constables, they will not say the psychological development of themselves. So we have no such records of those lower society persons in the Chinese tradition. The fiction then is the only source to inquire the psychological stages of those underlings during their actions of arrestments and interrogations. So if you consult those words, you may then find the descriptions of the novelists on those inside development of those what a vulgar person inside their heart. Furthermore, these novels disclose some embarrassing struggles and reactions of the judge in the fiction, which would never be mentioned in the case books. So in the plots of those stories, the psychological development and also the embarrassing situation of the judge would be mentioned, but it would not be the case of our case books. So more importantly, the psychology and calculations of the criminals are fully told in the fiction, which are impossible to obtain in the real world. So last but not the least, the reader knows almost every details of the crime, and he or she is well informed whether the accused is guilty or innocent. Thus, it giving us a powerful review on the effectiveness of the judicial torture in forcing the criminal to give on the tortured, not the criminal, to give honest testimonies. Indeed, contrary to the fictional world, nobody in the real court knows the comprehensive truth of an authentic case. Okay, I think we all clearly realize that. It is also true that the fictional details are very desirable to reflect the perceptions of the silent public and of the unsuccessful literati by whom the fictions are composed. I just mentioned the Stories to Caution the World is written by Feng Monglong when he was not an official. He's waiting to be an official. So many of them are unsuccessful in the civil service examination. So we know the viewpoints of those intellectuals, but they are non-official intellectuals. Okay, but towards the judicial torture. For example, in several stories of the Judge Bao, we are informed that the relatives of the victims may proactively request the judge to apply tortures to the arrested. So the relative would ask the usage, the application of torture. So it's demanded by the public. Thus, it seems that in the popular eyes, torture may be a preferred solution to solve the criminal case swiftly. So they wanted the injustice to be met at once by judicial torture. Contrary to Judge Yan's sentiments to the judicial torture, in the world of layman novels, this harsh legal apparatus is well treasured by all and plays the role of the ultimate weapon of judges to solve complicated cases. So I just told you in the last section that our judges reflected in the naming case books, they were quite reluctant to use the judicial torture. But it's not the same situation of the general public. They like it. They wanted the judges to use it. So it is impossible to explore fully all the parts of our naming novels concerning the judicial torture in this presentation. I would like to do it, but maybe for another cases, for another chances, that those details would be fun to share with you. But it is practical to compare the frequency of occurrence of successes of judicial torture in obtaining the true testimonies against those of failures in implicating the innocent to give false confessions. So we are told all these details by the plots of the novels. So as well as those of unsettled situation that the tortured persons refuse to admit the accusation, whether they are guilty or not. So we have the statistics here. The results are as shown in the PowerPoint slide. So in the celebrated cases of Judge Bao, you see the success rate of judicial torture to obtain the true testimony, the true confession is over 60%. That seems that in the eyes of the novelists, it is a very effective method to find out the truth from the culprits. In the world of the vulgar novel, Judge Bao, that means the merits of judicial torture to bring the truth to light, by and large overcome its evil in creating injustice. So failure is really above 18%. So compared to the success rate, it is a useful way of fact finding in the eyes of the commoners. Even in the same story, you know, when sometimes the judicial torture could not obtain the truth in the first place, but torture may have then, you know, make the innocent people to produce false confession. But eventually, in another one of torture, the injustice could be mended by making the real bandit to admit their crimes. So the torture applied to the innocent and also applied to the criminals. And afterwards, the criminals gave the truth. Then the case is settled. It is the, you know, the situation told by the novel of Judge Yan. Then, okay, I just mentioned that it's a vulgar novel that only perhaps the lower society will have the interest to read the celebrated cases of Judge Bao, because the plots are, you know, in our modernized day are rubbish, because they always, you know, have the divine intervention to solve the cases. And Judge Bao may have dreamed and know everything and see the details of the crimes, and then he just apply the judicial torture after he knowing the truth. For us, this sort of vulgar description or maybe cheap plots to the courtroom are rubbish. But how about the more learned novel stories to caution the world? Would it be different, or maybe the perception of the intellectual to judicial torture would be more conservative? So let's see the result. The proportion of success and failure of judicial torture in the stories to caution the world. So it's a learned novel produced by a celebrated writer from Mong Long. The success rate comparatively is still very high. It's just the same, or maybe even higher than the success rate of Judge Bao. So as demonstrated by the above figures, the favor to the merits of torture is overwhelming and closely agrees with that of Judge Bao. Therefore, we may conclude that in the eyes of the general public of Ming China, no matter they were elites, they are intellectual, more learned, or from the lower classes, the judicial torture was seen as an effective tool to expose the evil in the courtroom. The judicial torture in the fictional world, however, is somewhat different from that of the reality. Most of the tortures, I just mentioned, find in Judge Bao are handled by Judge Bao himself, who is a semi-immortal and uncorrupted man, frequently receiving divine instructions from the gods and ghosts through subtle signs. Maybe he just looking at the tree and see the pattern of the tree and know the truth. Okay, and also he always has some dreams or even personal journeys to the underworld to find the truth, to see the king of the hell and realize everything of the human world. So in most of the cases, Judge Bao may have already known the truth prior to the commencing of torture. To obtain the truth, he could administer tortures to some high officials and even a prince who are protected by the code of the deliberations by the codes of the Tang and also the Ming Dynasty. So what justice could not be brought to night by tortures or whatever means if a mortal judge, such as Yan Zhenyan and his subordinate officials, also sharing all such superpower and overcoming all institutional barriers of their times. So Judge Bao himself is a mighty deity, so he can solve the problems. He can, give us the truth, but it was not the same case of other normal judges such as Yan Zhenyan in our case books. So it's fun to know the general perception of the public, but I have to admit that it may not be the universal truth of all the general public of the Ming period. But anyway, from our limited sources, we see the inclination to favor judicial torture is very obvious. So the above are quite, just vague facts about judicial torture. Let's see something concrete about, of people from the late Ming and early Qing, just immediate after the fall of the Ming Dynasty, what they talk about the situation or maybe the details of judicial torture to us. I'm not going to give you gruesome stories, no worries. No blood spared, no such harsh things, but just some technical advices to see how the Chinese intellectuals, how they understood judicial torture in their nature and also in their applications. I'm going to give you the testimonial, not the testimonial, maybe instructions of a famous author and also one of my favorites, Ni Yu. If you have some impressions or maybe knowledge on Chinese erotic novels, the accounts of the J mattress. So it is famous for erotic appreciation. So he's famous in writing those books, but he's also a very popular writer, and he wrote everything. So he composed non-official handbooks for officials. That is the 知觉申诉, 心术 I'm going to discuss. This word I think is not very famous for everybody, but for the practical advices and also for reflecting the true practice of the court, this is very important for us to understand the 17th century. So Ni Yu began his essay by elaborating the different strengths between the old and new, and also moisturized and dry torture equipment. So it's very practical indeed, right? So how to give more force or less force by those torture equipments, it is the use concern. So, and he advised the officials should build a cabinet with doors to put the punishment equipments inside so as to keep them dry. Why? They should also apply the torture and corporal punishments according to the moisture contents of the relevant equipments, as the strength of beating of the same equipment when it is dry or wet could be very different. So he gave us some very practical calculation of the force. Sometimes cause accidental death of the tortured person because the equipment is wet. So Li then presented his key tricks on acquiring the truth from the suspects by the judicial tortures, which were neither mentioned in the case books or nor our naming novels. He mentions the following: the efficacy of the leg vice. Leg vice is the vice who capture the leg and pass it to nearly broken. So it's a very harsh equipment to enforce judicial torture. It's called 闸棍 in Chinese. So it's all the efficacy of the leg rise is all in the moment that it is about to pull up. So don't use it immediately. Try to intimidate the culprit. If in this moment the suspect admitted that he is the robber, then he must be the real robber, because the punishment or maybe the hitting wasn't yet to applied, or he admitted that he is the killer in the homicide, then he should be the real killer. It's the original word of Li Yu. So when the leg vice had been pulled up and then the beating of interrogative stakes was added, you may only accept 1/10 of the testimonies received in this period. So after its application, the credibility of the testimony is not that important or not that trustworthy. Even this 1/10 should be requestioned after the leg vice was released to verify if it is real. It's a practical advice. In many cases, that when a suspect refused to admit the crime in the first and second rounds of torture, even when he gave mouthful of admittance in the third, his testimony could not be taken as solid evidence, since what he told is not what he willing to deliver. So in the final reminder of his essay, Li predicted that the officials should only apply the torture to a very limited group of serious cases. It's his words. For all other cases not involving serious crimes, such as the homicide, the forcible robbery, and the high treason, it would not be a problem for you to abandon all of those severe legal measures altogether in your whole life. So his advice is not to use them as long as you don't encounter those serious crimes. So in other words, the judicial torture should only be seen as an exceptional instead of normal measure of integration. So these advices generally harmonized with the good practices of Yan Zhenyan, and they arguably reflected the public concept to the rightful usage of judicial torture in the late Ming and early Qing periods. Maybe the general people like that, the general population may prefer that the intellectuals, they have big reservations on those harsh measures. Now, so I think I have tortured you enough. Now, let's get to the conclusion. My conclusion is, it's still an oxymoron, or maybe some problematic words. The good practices in administering judicial tortures. So they should not be applied on those bad things, but how to do the good things, do good practices on those bad measures. So it's the spirit of my conclusion. His discontents to all its malpractices notwithstanding, Yan Zhongyang did never really challenge the existence of the judicial torture in the legal system. He only had problems with the malpractices. So if it is not paid by those unauthorized subordinates, it's fine. If the police constables, okay, they were not authorized to do this. If they don't do it outside the court, it's fine to have the judicial torture inside the courtroom by the rank officials, by the real judge, as reflected by the Ming China and two contemporaneous popular novels, all strata of the layman society agree that the judicial torture was a necessary measure of the judiciary. However, the general public even looked at it higher than the judicial officials did. So the public like it. The question is how to apply it rightfully. In general, the torture was seen as a special measure, using mainly, if not solely, in cases of serious offenses. In the light of the campaigns and experiences of Judge Yan, and also the stories of the layman novels, we may generate some concluding remarks concerning the good practice of judicial torture in the Ming period. First, the torture should only be administered by the principal rank officials of a court. It should be avoided by secondary subordinate officials. The police officers, by all means, must not apply unlawful tortures to the arrested persons privately outside the court. Second, tortures should not be applied to the vulnerable people as prohibited by the code. So those the elderly and the children should not be the target of torture, and also the pregnant women. Third, the judges should not see the testimonies produced by torture as reliable evidences. They better be suspicious to them until the testimonies agreed with all other circumstantial evidences, witness reports, and so on, after careful examinations and comparisons. Last but not the least, the torture must not be applied to the same suspect for more than 3 times at the same court. The judge had to observe the time limit for each section. The case might be seen as dubious if the suspect refuse to confess after the process of all wrongful tortures. The fact finding must stop here. So it's a limitation of the fact finding. Incidentally, except the essay of Li Yu, nonetheless, the 17th century China, in this century, few discussions were dedicated to evaluate the worthiness of the testimonies of the suspects given under torture. Thanks to Li Yu's sharing, the magic moment that the suspect may give the truth could be the very time the lake rise is about to pull up. But the tolerance to pain differs from person to person. This might not be seen as a universal rule. Okay, I can tolerate more pain than it's not applicable to me. So following the law of diminishing marginal utility, the confession produced after several rounds of torture is the most unreliable confession. So it is perhaps the most important point we learn from our sources. So it's tricky, it's almost useless of the judicial torture. Indeed, the truth of torture agreed by all our sources is that, if possible, not to use it at all. If it has to be employed, it should only be done after the judge had already cleared all doubts about the evidences of the illicit goods, the weapons, and the witness reports. It is according to the law. When he had everything ready but the confession of the real culprit. So it is the moment that the torture should be applied according to our traditional Chinese sources. In hearing a case that the magistrate of the first instance court applied ruthless torture to the arrested people, Judge Yan reported to his superiors in a case report about his sentiments when encountering those victims in front of them. So it is his code. Dozens of the family members from the same household, including the commoners and the slaves, and the young as well as the old, were beaten and severely injured. On the day of my rehearing, their complaints of injustice was loud enough to shake the heaven, and their blood and tears form a river. One's heart is filled with grief and corpses. One's hand in disappear, as if it is he's sitting in the cold wind and the bitter rain. So it's a personal experience written by our judge. Indeed, our layman judges well understood the shortcomings of torture in the legal procedure. In the succeeding Qing dynasty, this understanding had eventually created a trend of minimizing its application at court long before the legal reform inspired by the Western powers at the early 20th century. Thank you very much. It's the end of my presentation.
Thank you very much for a fascinating talk. Lots of information, and I'm sure we have a lot of questions. If I may invite everybody who has questions to chat them in, use the chat function, please, and let us have your comments or suggestions. If I may start with a question, how do you become a Ming Dynasty law expert? How do you become a Ming Dynasty torture expert?
It's not, indeed, it's not my intention to study torture because, okay, people hate them. And, you know, the first time when I discussed this sort of matters with my European colleagues on working on, say, English torture or maybe the torture in European continent, they really scolded me, as I am maybe a lover of these bloody things. But of course, I explained the situation of China and also my personal perception to torture. I thought, okay, I must make it clearly here. I dislike it. Okay, as those Ming judges. But the point that I like to work on this direction is mostly because of the influence of my colleagues working on the counterpart of the European side. They wanted me to compare the experience of the Chinese with like those tortures happening in Switzerland, for example, during the early modern period. And it's the first point that I reached this direction. And the second one is that you know, because I told you that I work with a team funded by the French government, and my teammates, you know, mostly the French. I'm sorry to say that it's not racist. It's just their tendency. Because okay, those French colleagues, they have a deep interest in those bloody things like slicing the person into pieces. Happened in the late Qing period. They collect those posters and created a website, and they want to inquire very seriously about maybe the practical experience of torture and also those those legal things, but imposing pain to a person, to see how they were understood by traditional Chinese. And because I'm working on the Ming law, so it is the possible direction that I'm okay, you know, obliged to work on. And more importantly, I have another experience on of research on the prison management of Imperial China. So the prison that you know, enclosing those possible criminals inside the official buildings. And I think they're closely related to judicial torture. So these two matters match perfectly. Is one of the other reasons that I want to understand more about judicial torture of the period. But the last point, or maybe the last thing that attracted me to look at judicial torture, especially in the Ming Dynasty, is that because the situation of the Ming and the Qing were quite different, and because we have many sources and also perceptions about the last dynasty of China on judicial torture, they were very negative pictures, and the public dislike it as reflected by the newspaper published in Shanghai and Canton and all those things. I want to know whether this is a long dislike, a long sentiment to judicial torture since the Ming. So I compare the experience of the Ming people with the Qing one, but my finding is quite astonishing, because the general public is not see those things as I know, or as I guess. It's totally different, quite opposite. And well, that's maybe those are main reasons. But for the Ming Dynasty, why I am interested in it is very practical. Because for the later dynasty like Qing and also the Republican China or modern China, the legal materials are so abundant that I don't think a single scholar in his whole life could handle them, could digest them to as a whole. But for the Ming Dynasty, it's possible for a scholar to to look at all materials and to give a maybe tentative conclusion to all those matters. So my ambition is to understand a whole dynasty. So the Ming is the one I chose.
Very good. Thank you very much.
Thanks.
Next question. Very interesting talk. Although Dr. Tam made it clear that we should not consider Western legal terms, there is an inescapable attraction to consider using case books to enhance good judgments as a form of precedent. Did the judges have any discretion in interpreting the code?
Yes, but the one of the main point, or perhaps the findings of my book Justice in Pain, is that our layman judges, when because they publish their cases, and we know the details and also their legal decisions. I originally, maybe myself and also some of my colleagues thought that the Ming judges may make their decisions quite arbitrarily, but it was not the case. They interpret the codes and also the regulations and impose the punishments to the criminals quite uniformly. And the uniformity, I think I've seen from those cases differed from cases, differed from maybe nature of crimes, but they are so uniform. It is amazing. So my conclusion is that they have some liberty to decide rather minor cases, but for those cases to be reviewed by superiors, like cases of crimes involving punishments of beating of heavy wood, heavy bamboo. They handle them, they understood them, and they have the legal interpretation of them quite in a standard form. I'm not sure whether it is because there was no formal legal training for those officials. They just received their education on those legal matters by reading books. But I suspect one of the main reasons for those uniformity is the widely circulation of the handbooks for officials. and also the commentaries on the code. They are widely circulated at that time. I'm still collecting evidence on the consultation of the judges to those interpretations, but few evidence reflected by the casebooks that they are coding the authority of those commentators. There's well, what I'm arguing is the emerging of sort of professionalism in the late Ming period, because they are following standard procedures, coding similar or the same authority for their legal decisions.
Very interesting. Yeah, a lot of what you said reminded me of what we are discussing on the term legal certainty, and which is, of course, one of the core pillars of our modern rule of law doctrine. Yeah. And it seemed to be very, very developed in the Ming Dynasty. At least there was a framework to ensure. Yeah, sure. Great, fascinating. Unfortunately, we don't have much time left, and maybe we have one quick question, one quick answer. Apologies to all those who've chatted in questions which we couldn't pose here. But there's one question here. Where do you find the case books? Are they published? How many are left?
Well, good question. For the details, of those case books, please consult the handbook prepared by Pierre Etienne I mentioned. There are, for the Ming Dynasty, there's at least 15 case books from different coastal provinces. For the inland of China, I'm afraid that they're quite limited. Maybe only just one or two case book left transmitted to our times. But for the Qing, for the early Qing, about the same size of legal cases is still available, extend to for our consultation. But for the later period of the Qing Dynasty, I'm afraid it's an ocean of cases. There would be more than maybe hundreds of thousands of those cases. It cannot be done, or it cannot be researched by any single scholar. But for the late Ming cases, the total number of case books is 15, and the cases contained in those case books, the total number is about 5,000. 5,000. The early Qing, that is before the Kangxi period, before the end of the 17th century, it's about 4,000. It's about 4,000. So 10,000 a total for our inquiry if we want to learn about the 17th century Chinese cases.
Okay, I'm afraid we have to close to stop here. This is fascinating. Thank you very, very much for a great talk.